Hey guys, my name is Shashwat and I'm a legal intern at LEXIS and Company. In this video, I'm going to talk about the liability of firm for wrongful acts. So, in this, the actually, what makes a firm? The partners collectively form a firm. All partners in a firm are principals on his behalf and agents on behalf of other partners. In the case of a firm, every partner is jointly accountable, and in every controversy, he takes a part and he is accountable for the wrongful acts done on the behalf of the other partners. In Section 25 of the Indian Partnership Act deals with the liability of a partner for the wrongful acts of the firm, and Section 26 and 27 of the Indian Partnership Act deals with the liability of the firm for wrongful acts of a partner or firm for misapplication by partners respectively. There is a vigorous liability of the firm. A vigorous liability means the liability of a person for the wrongful acts done by another. Vicarious liability is based on two maxims, which are quid facit per alium fact facit per se, which means he who acts through another does the act himself, and the respondent superior, which means let the superior be liable. The firm is made liable in case of two situations. Firstly, liability of the firm for wrongful acts of a partner. Secondly, the liability of a firm for misapplication by the partners. So, the Section 26 tells us about the liability of the firm for wrongful acts of a partner. All the members of a firm will be liable for the negligent advice given by one of them to the client of firm, or for the negligent conduct of the client's claim. The firm being a legalized entity, it is operated by its partners. The firm itself cannot transit its business contraventions of any law by one of the partners of the firm who would be contraventional by the firm itself. If one partner in the ordinary course of business of the firm commits a breach of revenue, all the partners will be liable for the consequent penalties. Then the expression injury in Section 26 indicates a tort. The liability of a firm for the tort of a partner rests precisely on the same principles as the liability of the masters of the tort of his servant. Basically, there is vigorous liability between the firm and the partners. Then comes the Section 27, which is the liability of firm of misapplication by partners. As per Section 27 of Indian Partnership Act, any money or property received by a partner from a third party vendor in the exercise of his authority is misapplied by the partner. Secondly, any money or property is received by the firm in the course of business is misapplied by the partner. Then the firm shall be liable for the same. The property so received shall be deemed as the property received by the firm. It is irrelevant whether the co-partners have the awareness of the delivery of that property, because a partner receives that money and property as an agent of the firm. However, the firm will not be liable for the property misapplied by the person when the partner or agent has got that property not in the course of business. Secondly, such property received by him not under authority of an agent but for his personal use. Will be the property misapplied, he will be liable. So I will conclude by saying that in the case of business, a firm and the partners to the firm are vigorously liable for the acts done. statutory liabilities have been imposed as a firm, and the partners may get involved with third parties in course of the business. The circumstances and evidence determine who will bear the liability.